Item number 1 to 5.
May it please, Your Lordship. Lordship, if I may pray, Your Lordship, I pray for some accommodation in this matter, Your Lordship.
Yes, please.
Your Lordship, I pray for some accommodation in this matter, Your
You are
Lordship.
appearing for?
For the petitioner, item number 1, Your Lordship.
You are appearing for the petitioner.
Yes, Your Lordship, in item number 1, Your Lordship.
These petitions are filed by the accused.
Yes, my lord. 2 to 5, my lord. Petition number, item number 2, 3, 4, and 5, my lord, filed by accused. 1 has been filed by the CBI, my lord.
What is the, you are for the CBI?
No, my lord. My friend is for the CBI,
I'm
my
for
lord.
the CBI, Your Lordship.
What is the prayer in your application?
Your Lordship, basically, Your Lordship, we have come by way of Section 482, Your Lordship. We are challenging the learned special judge's order, Your Lordship.
CBI,
Yes, Your Lordship.
you are 482.
Yes, Your Lordship.
Well, what is the order you are challenging?
Order dated 3/11/2022, Your Lordship.
Page?
Page 127, Your Lordship.
Page 127? Page 27 or 127?
127, Your Lordship.
What is your ground of challenge? The CBI petition?
My lord.
CBI has made an application under 482.
Now here what happened, my lord? There are 5 petitions listed together, my lord.
Which application? By the accused?
4 are by accused, my lord.
And 1 is by CBI.
1 is by CBI.
What is the content of CBI petition?
The CBI's petition is because, sorry, the order is at page 127, my lord. But here what happened, my lord? This matter pertains to selection to
Yes.
post of teachers, my lord.
They have filed an application 482 that it doesn't disclose an offence for quashing of the proceedings.
my lord, that is,
I said that application would be heard out. In the meantime, you cut short your list of witnesses, 128 witnesses, etc. And what is the CBI petition about?
The CBI petition, they filed one application before the trial court, my lord. In a selection committee, there are 4 members, my lord.
Huh.
Now, they are all witnesses, prosecution witnesses before the court, my lord. They want that all 4 should be examined in chief first, and then cross-examination should start. Normally, what happens, my lord, one witness comes, he is examined in chief, and then he is cross-examined. They want that all those 4 witnesses should be examined first in chief, that cross-examination should be deferred.
Because of mental capacity and all that.
No, my lord. Because they are saying that if they cross-examine one of the witnesses first, my lord, their defense will be disclosed. Now, may I take you lordship to the application filed with them, my lord? That will clarify, my lord.
No, but what is the position before the criminal court? Has it
Page
proceeded?
118 is the
Evidence is
application.
going on, my lord.
Huh?
Evidence is going on. Evidence is proceeding, my lord.
Page 118, my lord, of this petition. One one eight, my lord. This is the application filed with them under 231 CRPC, my lord. And the prayer was, my lord, at page 120, lord, so kindly sees. Please to defer the cross-examination of Sri Chalang Marak, P.K. Boro, V.D. Kinjing, and Sensible Marak to a date when after the examination chief of the said witnesses is completed by the prosecution. Para 5 is the ground, my lord, at page 119.
These are the witnesses.
These are the witnesses, lord. So para 5, lordship kindly sees page 119. What is their contention, my lord? That in such circumstances, it would be in the interest of justice that the examination chief of the 4 members of the Dadangiri Center, including the chairperson and the member secretary, is recorded first, and then the cross-examination is conducted one after another in order to prevent the disclosure of defense to the other common witnesses as stated above, which would in turn jeopardize the right to fair trial of the applicant accused persons.
Disclose the defense. Whose defense?
The accused person's defense one. But there was the application filed by accused person before the trial court, my lord.
No, all right, but how would the witnesses disclose the defense of the accused?
They are saying that if they put cross-examination question to witness number 1, for example, my lord, in this case, the other 2, 3, and 4 will know the strategy of the defense. What is their strategy? But that is our case, my lord. That is in our humble submission. That is not a case for taking an unusual course, my lord, of examining in chief all the 4 witnesses, then start their cross-examination. And that is why we have come up with Honorable Court.
The red pen. The red. The red pen is not there. No, this. And this was allowed.
This was allowed. This was endowed very tangentially, my lord. Even if I read the order, my lord, impugned order.
Page 127.
My lord. My lord, page 127 is not very clear because the court is dealing with two issues at same time, my lord. So that's a very confusing order, my lord. Because one of the issues was mental health of one of the accused persons, my lord. And the other issue was this, my lord. At page 128, the last paragraph, starting from the prosecution, my lord, this is relevant for our purpose, my lord.
Granted the prayer of the accused day one.
My lord.
That means one after the other.
Chief examination chief, one after the other, my lord.
And then cross-examination
Then
together.
cross-examination will start, my lord.
You have challenged this in 482.
I have challenged this order.
And your application? It does not disclose a cause of action.
My lord, actually, this is filed by A2, my lord. A2, who is my lord, who is led by my lord, Mr. Khurshid, my lord.
My lord, may I clarify, my lord?
Yes.
Item number, petition number 37, 70, 71, and 72, my lord. Item number 2, 3, 4, and 5 in today's list.
Yes.
Well, so that is petition number 37 and 70, my lord. 71 and 72 are for quashing of the charges, my lord, filed by the accused persons.
70 and
37, 70, 71, and 72.
'72 is also there.
So 12, my lord. I've wrongly written. The last item.
36,
My lord, 36, 37,
70, 71.
70, and 71 are filed by accused persons for quashing of the charges, my lord. And 12 of 23 is filed by us, my lord, the one I just placed before lordship.
So what is the stage of the trial now?
Evidence.
21, 22 witnesses have been examined in the case, my lord.
In fact, the witnesses, my lord, it is more than 400, my lord. It has been wrongly reflected as 177. It is more than 400, my lord.
The witness list has not been cut short up to now.
My lord, we are proposing to cut it short, my lord. But because the matter is coming after some time, I can have instruction on that, my lord, and how much they can cut it short, my lord.
So how many witnesses have you proposed to be examined?
What we submitted on last occasion was 170 something, my lord.
It is more than that, my lord. It is 400 plus.
How many have been examined up to now?
21, 22, my lord.
So here what happened, my lord, this matter pertains to recruitment of teachers, my lord, in primary schools in the entire state of Meghalaya. So the discrepancy was found, my lord, and it was found that there was large-scale manipulation in the selection process, my lord. This honorable court directed for a CBI inquiry. And pursuant to the directions of this honorable court, my lord, CBI took over the matter, concluded the investigation and filed the charge sheet, my lord. And the then education minister of the state, my lord, and then director of education, my lord, they are the two of the accused persons.
Now she is not a minister.
Now also, this is a law minister, my lord, of the state.
His examination of witness is going on.
Yes, my lord.
When is the next date?
It's in the March. Uh, 3 to 7th March, my lord. 3rd to 7th March.
Fixed consecutive dates.
Consecutive dates, my lord. From 3rd March to 7th March, my lord.
This is the 21st witness.
Tentatively, my 21st, 22nd, my lord. That I have to confirm, my lord. But it is not more than that, my lord.
My lord, why the witnesses list is long, my lord? Because the illegal appointees, my lord, they are the witnesses. Because certain documents have been seized from them. That is what has made the list very long, my lord.
No, seize from them. The person making the seizure will be the witness. How will that person be a witness?
Because there's an angle of conspiracy also, my lord, because between the candidates, minister, and director of education. My lord. So, my lord, I'll talk to them, my lord.
Suppose there is a bank fraud and 1 lakh bank customers have been defrauded. Now, 1 lakh customers will not be called as witnesses. The person who can depose with regard to the fraud will only be, and his evidence will cover the fraud practiced on all the customers.
My lord,
As a matter of example, here also it's a kind of a large scale mega thing. So individual persons who have been victims need not be called.
not victims, my lord. They got the benefit of this manipulation. My lord.
Yes, but then somebody who knows about everything as a whole should be called as a witness and not micro.
That is true, my lord. Otherwise, the trial will
For
never.
that, they need legal counseling from you. So this is also pending, those examination in chief and then cross-examination one
Witnesses
by
have
one.
not been examined till. Those 4 witnesses have been kept aside, my lord, for the time being, till this matter is decided. My lord.
They call the makers.
All right, please take down. By my order dated 9th December 2024. I had indicated a desire of the court for early disposal of the criminal case. Full stop. This court had inter alia observed that the prosecution had a long list of 162 witnesses and that it would be in the ends of justice if this list was cut short. Full stop. Amongst other things, it would facilitate early conclusion of the proceedings. Full stop. It was left to the CBI to take a decision on the issue. And the learned criminal court to decide. Further examination of witnesses. Till that decision was made by CBI. It appears that such decision is pending before the investigating authority, the said investigating authority, full stop. In the meantime, around 21 witnesses have been examined. It was submitted by learned counsel for the accused that the number of witnesses proposed to be produced by CBI has now crossed 400, which fact learned Deputy Solicitor General is unable to confirm today. Paragraph. It goes without saying that this exercise of examination of witnesses is subject to the result of the application under Section 482 of the Criminal Procedure Code. Applications made by the accused for quashing of the criminal proceedings. Paragraph. It is also submitted that the learned trial court has fixed 7th, 8th and 9th.
Third, my lord.
Third,
Third till
fourth.
7th. Third till 7th, my lord. Third till 7th.
3rd, 4th, 5th, 6th and 7th March. For further examination. Of the witnesses for the prosecution. Paragraph, we direct that the learned trial court may proceed with the examination till 7th March. Full stop. By that date, the CBI should indicate to the learned criminal court whether it would go ahead with examination of all the witnesses or with a limited number, or seek further time to consider whether to produce the current list of witnesses or a truncated list. If the CBI has taken a decision, the learned trial court will proceed. If it seeks time, further time to take a decision on the issue, further examination of witnesses will be kept in abeyance till that decision is made by CBI. Paragraph. In the meantime, this court would hear out the applications of the accused under section 482 CRPC, along with the application under the same provision made by CBI. List the said applications. On 6th March.
At 6th March, I have some difficulty, my lord.
Then make it earlier, 5th or 4th.
Well, that week I'll have to be out of station for some wedding, my lord. Maybe a week before that or after that, my lord.
Week before that is February, difficult.
A week after that, my lord.
All right, 11th March, marked at 10:30 a.m.
Well,
The Learned Registrar General is directed to communicate this order to the learned court below. Yes, please.
May it please your lordship. Well, first, I apologize before your lordship for mentioning one matter. Item number 5. My lord, this matter has come up for hearing on 13th of December 2025. Year 24, your lordship has admitted this appeal and asked to prepare a paper book and hand over on 10th of February. We have done it. Once I went back and I studied the brief, I have seen lot of markings are there with certain notes which is in before the registry. I feel a bit of embarrassing, my lord, writing note and lot of duplication. I have seen lot of pages from 391 to 451. So may I just humbly pray before your lordship, if some time is given, so that we can correct it and hand over to the registry.
Your upon notice, the other side is present.
Yes, yes, I already informed the Advocate General also. my lord.
AG informed, my lord.
I really wanted to do virtual, but I hate doing virtual. That's why I came myself here, my
All
lord.
right. Item number 5.
5,
The
my lord.
hearing list, my lord.
Leave is granted to advocate on record for the appellant to take back the paper book filed in the registry and to replace the same by when?
Well, whichever is 10 days time, I think I can do it.
By 28th February.
Yes. 20.
Serving a copy by that date
Yes, sir.
on the advocate on record for the
Respondents, my
respondents.
lord.
The date for hearing of this appeal is rescheduled to 12th March
12th March.
2025.
I'm sorry for troubling the,
No,
the court. So if it is not inconvenient, can it be after 12 any date which is convenient for the court?
After the holy break.
Yes, after 12 any date which is convenient.
All right, 19th March.
Yes, fine. Deeply obliged.
Item number 1.
But this is a habeas corpus petition, my lord.
Yes.
And my lord, primarily two issues arise, my lord, in this matter. First is, my lord, whether the 24 hours requirement under the Constitution of producing before the magistrate start from the time of official arrest or from the time he is apprehended, my lord. So that is the first question, my lord. Second question, my lord, in this case, my lord, whether your lordship will appreciate the conduct of the police, my lord, and whether we are going or we want to become a police state, my lord, in this country. My lord, here what happened, my lord, I'll just take a lot to the facts, my lord. My lord, there were some private transactions, a commercial dispute arose between the accused person and so the complainants, my lord.
Yes.
And 3 police cases were filed by the complainants, my lord. One in Khanapara, one in Bagmara, and one in Pura, my lord. Now, my lord, I'll take your lordship to the order passed by this honorable court, my lord. Page 12, my lord, is the first order of bail. But page 12, your lordship kindly say this was order passed by this honorable court, my lord, on 24th September 24. The accused person was granted anticipatory bail in this case, my lord. This is pertaining to Tura police station case, my lord. Now, my lord, page 20 is the interim bail, my lord. We got, my lord, from this honorable court. This is in respect of Bagmara case, my lord, at page 20, my lord. Then, my lord, we again approach this honorable court with regard to the third police case, my lord. And lordship will find at page 23, this honorable court was pleased to grant us interim bail on this case also, my lord. With a direction that we should cooperate with the IO, my lord. Now what happens, my lord, after these orders were passed, the accused person goes and appears before the Khanapara police station, my lord. My lord, he reached police station in morning, my lord. He was detained, and not only that, 2 lawyers accompanying him, my lord. Everybody was detained, my lord. Their phones were snatched by the police. And knowing very well that there is an interim order, Khanapada police cannot arrest him, my lord. What they do, my lord? They inform Tura police, my lord. Tura police arrives there in the evening, my lord, on 16th of February, my lord. And your lordship will see page 25, my lord, kindly. Well, page 26 is a typed copy. I'll just read this matter. The Government of Meghalaya Office of the Officer who is in charge, Khanapada Police Station, to Medical and Health Officer so and so, medical requisition and opinion thereon. Sir, madam, with reference to the above, I am sending here with the below noted person. He is detained in connection with MWPS, that is Women PS case number so and so, dated so and so, and Women PS case number so and so, under section 351 so and so, 3961 of BNS, read with 18 POCSO Act, my lord. And my lord, kindly note, my lord, before that, my lord, reference Khanapada PS GDE number 16 to 25, my lord. So, my lord, after I obtained bail in all three cases that were known to me, my lord, and when I go to IO to appear, my lord, they register a case against me under POCSO Act, my lord. This is pure attempt to circumvent the order passed by your lordships, my lord. That's one, my lord. And it doesn't stop there, my lord. Now, my lord, they take him to Tura, my lord. Now, my lord, there is a court of magistrate. Law requires that any person must be produced before the nearest magistrate within 24 hours, my lord. They don't produce him in Nongpo court, my lord. They take him to Tura, my lord. Now, what they do, my lord? They register another case in Ampati this time, my lord. And that the FIR is, because that FIR was not available with me at that point of time, my lord. They register another case in Ampati police station, my lord, and they arrest him, and he is languishing in custody now, my lord. Now, the question that arises before lordship's consideration is that he appeared before the Khanapada police station on 16th of February morning time, my lord, and he was produced before the court of Ampati yesterday, that was on 19th, my lord. So the question before whether his detention for about 3 days, my lord, against the mandate of law which requires production within 24 hours. That is one aspect for your lordship to consider, my lord. The second aspect, my lord, can the police be allowed to circumvent the order passed by this honorable court in this manner, my lord? After I get bail in 3 matters, my lord, not only that, my lord, the police demands 10 crore rupees from the accused person, my lord, to settle the matters.
You see, your remedies before the appropriate court. Habeas corpus means produce the body dead or alive.
My lord, I'll just place
Where the existence of the person is not known and is in police custody but not known, whether he is, where he is, in which state, then this writ is issued by the court asking the authorities to produce that person. So the whole if it is habeas corpus is translated into English, it is produce the body dead or alive.
my lord. If in case of illegal detention,
But here you know where the accused is.
my lord, when we filed this application, we did not know, my lord, but yesterday evening we came to know that they are going to produce him in Ampati in connection with, now 5 cases have been claimed on him, my lord. 3 he got
Where is
bail.
the accused?
Lordship,
No, my lord, only one submission before that, my lord.
Yes.
If lordship can, I'll place one judgment of Telangana High Court, very recent decision, my lord, where the Telangana High Court held a division bench of Telangana High Court, my lord, in a habeas corpus matter, that if detention has to be counted, the 24 hours has to be counted from the time he is apprehended, my lord, not from the time of official arrest. And the honorable
That is a
Telangana,
different matter. That is an entirely different matter.
my lord, this is our case, my lord, that he was not produced before any magistrate within 24 hours from the time of his detention in the
Then
police
it is
station.
not habeas corpus. It would be mandamus, whatever it is, under 226, if it lies, or any criminal proceeding.
My lord, this petition is otherwise also under 226, my lord. So lordship may take note of that. My lord kindly issues a mandamus also, my lord.
Then you file a supplementary affidavit enlarging the scope of the petition.
My lord, only one thing, the Telangana High Court, in habeas corpus matter, my lord.
May have, but then habeas corpus, it is beyond the scope of habeas corpus, Mr.
My lord, I'll just refer to 2-3 paragraphs, my lord, kindly, my lord, of this judgment I have for placement. But I'll refer to para 2, subpara A, my lord, in the beginning. Now, my lord, the facts at para 4, my lord, may I just read, my lord, a few lines here. The ratio of judgment in 10, 11, and 12, my lord. And my lord, the concluding part is of para 27, my lord. The Honorable Telangana High Court directed for forthwith release because he was detained more than 24 hours in the police custody, my lord. By issuing a writ of habeas corpus, my lord.
Three and four were
They were produced within 24
not
hours.
produced.
3 and 4 were,
Need to be released.
my lord. 1 to 3 because they were apprehended later, my lord.
Yes, but the application of the writ is not right. Habeas corpus does not entitle a court to release.
My lord,
Habeas corpus,
my lord, in writ jurisdiction, my lord can amend.
habeas corpus
Well.
is a writ issued by the court directing the detention authorities to produce the person detained before the court
So, my lord, what I would pray, my lord,
to ascertain the grounds of detention.
my lord, what I would pray, my lord, this is purely commercial dispute between the complainant and the accused persons, my lord. My lord, even you will also see the sections 406, 407, 420, my lord. There is not some heinous crime committed, my lord.
Already produced. Your client has already been
He has been produced, my lord, before the magistrate. But, my lord, we We took this plea before the magistrate also, that he has been apprehended on 16th and is being produced on 19th evening, my lord, before the magistrate. That is much beyond 24 hours, my lord. In fact, it is about 70 hours or 72 hours, my lord. But the London trial court, what it holds, my lord?
Fresh petition on that positive. He's identified already produced.
And my lord, the conduct of the police, my lord, it is very unfortunate, my lord. He goes pursuant to the order of this honorable court to the police station, my lord, after getting an interim bail, as if there is a red corner Interpol notice, my lord. A police in different district, my lord, detains him, calls that police, you come here. They pick him up from there, my lord, as if we are in some police state, my lord. Then they take him for POXO case, my lord. They don't produce him before magistrate in POXO case, my lord. Then on 17th, they register another case in Ampati, my lord. And in a civil dispute, these are all attempt to circumvent the order passed by this honorable court, my lord. My lord, in my humble submission, if lordship permits this, the state must be careful, my lord, while dealing with the honorable court, my lord.
You want to file a fresh petition or file a supplementary affidavit? You tell us.
My lord, I'll lordship, whatever lordship, but my lord,
It is difficult because the office you are enjoying, you will appreciate it as much as we do. Now that he has been produced, it is difficult to maintain this writ as framed. So the choice is yours. You file a fresh proceeding or file a supplementary affidavit.
but in that case, lordship grants us leave to withdraw this with the liberty to file a bail application, proper bail application with this honorable court. But in my humble submission, my lord, in the facts and circumstances of the case, my lord, your
You will
lordship,
record that.
lordship would invoke the 226, my lord.
This is an application under Article 226 of the Constitution of India, praying for issuance of a writ in the nature of habeas corpus. Paragraph. The ground which was sought to be urged by Dr. Muzika, learned counsel for the petitioner, was that his client was detained by the police for a period much over 24 hours from the time of detention bracket, which according to the submission of learned counsel was the time when the petitioner was arrested, bracket close, without being produced before any court. Full stop. Furthermore, the police was trying to harass the petitioner by moving her across different police stations and trying to saddle her with new charges.
It's him, my lord.
Oh, sorry, him.
My lord, may I make a submission, lordship?
No, not now, after the order.
Lordship.
Paragraph. Now it appears from the submissions made by learned counsel for the petitioner, as well as Ms. Shaila, learned additional Advocate General
My lord, I am the public prosecutor, lordship.
and public prosecutor. That the accused has been produced in court paragraph. The paragraph, the court entertains a writ petition in the nature of habeas corpus when it is brought to the notice of the court that a person has been taken in custody or detained by the authorities and his whereabouts have not been disclosed by them or is unknown. Full stop. It is on that cause of action that the court issues a writ to the authorities to produce that person in court to ascertain whether that person is dead or alive, or whether that person is alive, and if so, in what state the detaining authority has kept him. Paragraph. Since now the accused has been produced before the court, paragraph, the alleged cause of action in this certiorari writ does not survive. Paragraph, we dispose of this writ with the observation that in the changed circumstances, the writ petitioner would be free to take any appropriate legal proceedings concerning detention or production after detention in before the court. Or any other matter relating to the alleged offences that the petitioner is accused of, in an appropriate jurisdiction. All points are kept open. All right. Yes, you would like to say anything?
Lordship, actually, there was an anticipatory bail moved by the petitioners, my lord, before court number 3 on the 18th. And the same submissions were recorded, my lord, in that anticipatory bail order dated 18 of...
What was recorded?
Lordship, with regard to the detention of, the alleged detention of the accused persons, Lordship.
Maybe that doesn't.
My lord, two things had happened after that, my lord. POCSO case clamping and a case registered at Ampati, my lord.
That fresh charges have been brought, etc. It is.
My lord, at least they have stopped now after we served the habeas corpus petition yesterday, my lord. At least now they will not clamp another case, my lord.
Yes.
Item number 2.
Service not complete.
My lord, out of 28, we've been able to serve 27, my lord. Only one is left, my lord.
All right, this application is further adjourned till
Respond on 16.
3rd March to receive the service report.
Well, the-
Item number 3.
Yes.
is that IVF matter, my lord?
We will take this up on Monday
My lord.
because there is another bench now with Justice Bhattacharya. Would you like to say something?
No, my lord, we have filed affidavit, my lord. Our stand is legal stand, my lord. But the lordships have directed that hospital in Guwahati, my lord,
My lord,
by last order.
I am appealing for the hospital, my lord.
You file an affidavit.
My lord, just pay for 10 days time to file my affidavit, my lord. We
Why?
just received the notice, my lord,
When?
on 18 evening, and I had been given the brief yesterday, my lord.
You are not prosecuting your...
Immediately, my lord, we have sent
Then how come he has received it on 15?
It's 15 delivered.
On 15, my lord, it was delivered.
We have filed affidavit.
We have already filed our
This one is fine.
We directed the Registrar General also to serve.
My lord, that was received on 18, my lord.
And their service?
15.
We have sent it on 13, my lord, and it was received on 15.
Then after 5 days.
It was received by them on 15, my lord.
2 days.
Considering the delay made by the petitioner, by the registry of this court and by the petitioner in serving the order dated 10th February 2025 on the hospital authorities. The time to file the affidavit by the head of the Institute of Human Reproduction, Guwahati, in terms of our said order, is extended till 28th to 8th February. List this writ petition on 4th March.
Obliged.
The-
All the hearing matters?
Item number 4.
But this is the matter regarding reimbursement of medical expenses, my lord.
We will take it up on Monday. There is no time today.
Monday.
There is another bench figure,
March.
Monday. This writ petition is adjourned for the day. Next. What's the last matter? It's already. Yes.
Item number 1.
May I please, Your Lordship? The other day, Lordship had pointed out that there are two issues. One is, of course, the issue relating to being fence-sitters and whether the judgment is in rem or is in personam. To that extent, probably some submissions were made, my Lord. To the other query, that after coming out the recruitment rules of 2002, how do we overcome that particular hurdle, my Lord? Because that observation, Lordship had seen that at para 25 of the judgment has also been made by the learned single judge. To reply to that part relating to the recruitment rule, my Lord, I would come to initially page 13 of my paper book again, which is the judgment rendered earlier by this court in 2012. Now, this repetition, my lords, was also instituted in the year 2010, which is after coming of the recruitment rules of 2002. What the recruitment rules of 2002 did was that it had made the initial post of clerks at the entry grade to be a post of Havaldar. So therefore, page 13, Lordship would see that those petitioners who were earlier there before this court, they were holding the post of Havaldar clerk, and some of them, 4 my lord at page 13, all those petitioners were also, my lord, Havaldars. Then some were promoted to Naib Subedar, then Subedar, and some were even Subedar Major. The claim in the earlier round of litigation was that the initial post should not be Havaldar, it should be ASI or in the rank of warrant officer. So the earlier persons who were there were also Havaldars, my lord. Because after 2002, the initial post had become a post of Havaldar. So therefore, my lord, the finding at page 23, para 14 of the learned single judge earlier is that the Assam Rifle should take up the matter with the Ministry of Home Affairs to bring parity in rank structure and pay in the clerical trade at par with other CPOs by introducing the rank of Assistant Sub-Inspector at the entry grade. So the entry grade post was to be changed from Havaldar to ASI or Warrant Officer, my lord. That was the direction given. And it was for the entire clerical trade, as I had pointed out the other day. So this got, my lord, upheld in the Supreme Court. And in implementing at page 31, my lord, again, I would invite your lordship to have a small look. Page 31 in my paper book. This is the approval of the Ministry of Home Affairs in consultation with the Ministry of Finance. They say that para 4, now Assam Rifle is requested to implement the judgment and order dated 23/8/2012 of the Honorable High Court Shillong Bench, both in case of the petitioners as well as similarly placed employees, by introducing the rank of Assistant Sub-Inspector at the entry grade with effect from 1/1/1986 in the pay scale of so-and-so and revised pay scale of
Which
so-and-so.
page you are reading?
My lord,
Which page you are reading?
page 31, my lord. Page 31, para 4 of the implementation order of, this is the approval order of the Ministry of Home Affairs. On 21/6/2016, they say that you introduce this rank now for the petitioners as well as other persons. Other persons means, my lord, in a particular trade, there cannot be two entry level posts. Some cannot be called Havaldar, some cannot be called warrant officers. There has to be one entry gate. It is either Havaldar or either warrant officer. So therefore, probably the court had also earlier rightly said, and the Ministry of Home Affairs has also rightly said, that you introduce it at the entry grade, the post of warrant officer, and give it to these petitioners and also to the others. Others, my lord, naturally are the other persons who are also serving as Havaldars. Now, Assam Rifle, of course, had the option thereafter to amend the recruitment rule and introduce that particular post. They didn't do so. They introduced the post as an ex-cadre post, maybe because it does not still find mention in the recruitment rules till today. That post got introduced, and my lord, the benefits were extended. However, what the Assam Rifle initially did is that they said that while implementing the order, that people who are recruited post 2002 will not be given that rank of warrant officer. Therefore, this 87 persons who were left out from the earlier order came, they were granted. Then 192 others also came, my lord, who are also appointees after 2002, they are also granted. But in our case, my lord, somehow we were stuck because of maybe delay in approach of the court, and also for the fact that the court observed that you could have probably challenged the recruitment rules of 2002. My lord, my humble submission is that we need not, or we are not required to challenge the recruitment rules of 2002 because the court had earlier given a clear finding that the introducing and the initial rank and post for clerks would be the post of ASI and not Havaldar. And that has been implemented as per direction of the Ministry of Home Affairs. So now what has happened is, my lord, that there are two people who have been given benefit of the judgment. Their opening rank is, my lord, warrant officer, and those who have not been given the benefit of the judgment, my lord, their initial rank is Havaldar. So there cannot be two initial ranks, my lord.
Judgment and order once again
My lord.
of the learned single judge.
We come to, my lord, page 23 is the effective direction, my lord, of the learned single judge in the litigation of 2010. Page 23.
No, the impugned judgment.
The impugned judgment, my lord.
Page 59.
Page 59. Page 59. Lordship had, on the last date, actually asked me to clarify on this aspect of para 25 had Lordship had referred to. Para 25, the page 70, the learned court says that you had not joined issues with colleagues in the first round of litigation, firstly, and secondly, there is no question of seeking parity as you are enrolled, as they are enrolled under the relevant recruitment rules of 2002, and these rules have not been challenged. In my humble understanding, my lord, challenge to these rules is not required because it has already been diluted down by the earlier rounds of litigation, which says that now the initial post would be ASI, not Havaldar. It's the Assam Rifles' fault that they have not amended the recruitment rule, and without amending it, they have introduced that post. And if that post is introduced, my lord, it has to be introduced for everybody. There cannot be two ranks at the initial stage for persons, my lord, who come and serve there as clerks.
The present writ petitioners are not part of the 89 writ petitioners.
No, my lord. That is why they were said to be fence sitters, my
Those
lord.
89 are also post 2002.
Post 2002. Not only that, my lord, there was another litigation, my lord, which you could see at page 52, flag 9. Pursuant to another order passed by the Apex Court at page 50, where SLP of the Assam Rifles was dismissed, 192 other persons, my lord, who are post 2002 appointees were also given the initial rank of warrant officer. The apparent logic, as I understand, my lord, is that once you introduce the rank of warrant officer as the initial rank, it has to be uniformly introduced for everybody. There cannot be two initial ranks for the same service, my lord.
The 2002 regulation is 29th October.
My lord.
Gazette notification GSR 472, page 64.
My lord. Page 64. What probably was missed out here is that, my lord, in para 12, while noting that, is that in the 2010 litigation, my lord, the issue was that the initial rank should be not Havaldar, it should be ASI. And that was the finding of the court. And accordingly, it was modified, my lord, by the Ministry of Home Affairs.
You have concluded, Mr. Counsel?
My lord, these are the two sum and substance of my argument.
How much time are you likely to take?
Your Lordship, here in this matter, I don't take too much time, Your Lordship. Here, Your Lordship,
No, how much time you are likely to take in your submissions?
10 15 minutes, Your Lordship. 10 to 15 minutes.
You'll finish? Yes.
Your Lordship, here in this case, we are having twofold of argument here at the moment. That's one set of the employees, they have given the benefits subsequently to this writ petition filed by the petitioner. My submission here, Your Lordship, first of all, we have taken in our affidavit the 87% who has given the benefit, though they are recruited after 2002. There was apparent mistake from our side.
You did not want to give it because they took contempt proceedings, you were compelled to
Yes,
give it.
Your Lordship.
Right?
So you will see this is the matter. Because this matter has come up, it is stable up to the Supreme Court. We didn't point out. So ultimately, we compelled to give them the benefit. Subsequently, what's happened, you will see another set of litigants come up, 192. When we approached before this court, then after this court has passed the order to consider them because their junior are already in the senior position. So matter was already tabled to the Supreme Court. So that's why we have preferred the matter to Supreme Court and it was delay. In this delay, Your Lordship, Supreme Court considered and then Supreme Court says to extend to the benefit to the assembly this page 50 of this paper, Your Lordship. May I read, Your Lordship? It's ordered, Mr. Heard Mr. Vikram Banerjee, learned SG appearing for the petitioner, the matter pertaining to the respondents who were working the Assam Rifle under the impugned judgment, the High Court granted them relief toward their seniority placements and related pay benefit by their colleagues in the same organization. So, Your Lordship, in this set of the litigation in 2010, it is happened that's the person, when 87% is given the benefit, they are the junior and some senior before that were they appointed, they approached before this court, and on this court has considered as because they are junior getting the pay more than this, so it should be considered. So ultimately Supreme Court also don't consider about it. That's where the issue is. So we have ultimately implement this order. So in this case, Your Lordship, the petitioner is there. They are neither been affected out of giving this 192 persons who are giving the benefit. So they are claiming this, Your Lordship, as a claim their negative equality. Petitioner is not having any fundamental right in this matter, Your Lordship. They are claiming based on the negative equality. Your Lordship, just we have committed the wrong and then we have to continue this wrong. So learned singles rightly consider, Your Lordship, that the petitioners here, the appellant here, they are not entitled for any relief based on the recruitment rule. Here this, Your Lordship, the appellant here, when they have been recruited, then they are knowing about this, what's the recruitment thereof. Subsequently, they are asking for the rationalization pay and scale, who has appointed since year 1986 onward. So, Your Lordship, if you take into look into the matters of this, about the pay commission, full pay commission. See, here, fourth pay commissions and fifth pay commission when come up, there was parity in the pay. And due to this, warrant officer was introduced as a intermediary post. To rationalize the post, all EPMF. So, Your Lordship, here, when this appellant has entered into service,
This. What is this judgment and order? You come to page 50, Supreme Court. Your delay was not condoned.
yes, Your Lordship.
But the judgment of this court is 17-23. Where is the judgment?
That is at page 37, my lord. Ajay Kumar and 191 others. These are also, my lord, appointed after 2002.
Who preferred this writ?
My lord, these are 192 other clerks, my lord, who were also appointed after the 2002 recruitment rules had come into place. They had sought parity because they said that you have already implemented it in respect of others who are appointed after 2002.
Further 194.
Further 192. my lord.
Not those 187.
Not those 87. Further
Your
192.
Lordship, here, just I clarify, Your Lordship. Here, this, Your Lordship, this 192, their senior to them in 87. You received 87 was the main writ petition. And this 192 is
So
senior.
first batch of writ petition, 187 were left out,
Only 87.
87,
87.
contempt regularized.
Here you
It
receive
is
above,
others by 194, plus 194.
190.
you receive what's well. There was a
192, my lord. 192.
1,300 MP was there in the first petition. In this one,
And this present one, how many?
My lord, 635, my lord. These are the left out persons, my lord. My issue is that, my lord, the paradox that has arisen now, that there are two entry gates. How can there be two entry gates, my lord?
Yes.
you receive, my submission is even in my affidavit also I have taken. That had it been at that point of time when original release in 2010, it was brought to the notice of the court that 87 are not entitled, then matter could have been deferred again, you receive. So this one, even up to the Supreme Court, you receive, we didn't point out these matters. So ultimately liabilities come up for 87. So when we have considered 87, you receive, then this 192 persons, they are senior to this 87. So they left out. So there is differences. So to enumerated to all this enumerated to solve it, you receive, court has passed the order to give the benefit to 192. This 198 of 2019.
All right. We have got the word.
So you will see, ultimately we have appeals to the Supreme Court, but there is a delay, it is not considered. So this is a final judgment, nor law of the matters is decided, law point has not been decided. So you will see, ultimately when Supreme Court has dismissed our appeal, so we have considered 198. So now this year appellant is here, they are saying as because 87 earlier given and this 192 persons, those are the senior of this 87, we have given the benefit. So this benefit to be extended to them. We are saying as per recruitment we can do, but we have given the basis of judgment, so we are not in a position to give because our recruitment in force. And they are bound with the recruitment rule. So this is our.
That's all?
This is something.
All right. My lord. You are concluding the hearing?
My lord, just...
No, nothing. We reply only on law.
My lord, only on law.
What is there on facts?
My lord. Facts there is nothing. Facts there is nothing. I will submit a short notes if lordship permits, my lord.
Hearing concluded. Stop CAB. Advocate on record for either party is at liberty to file written submissions by 2/8. 1 week we are giving them.
My lord, definitely.
2/8.
Just my
2/8 February.
what's the submission I have given, this short note I can give.
You prepare a proper short note and file. You are getting 1 week time. You file it
My lord.
with court master attached to this court.
I'll give the citations also, my lord, on pay parity. Not
You have
place.
cited them.
I will cite it with my lord
No,
notes,
no.
my lord.
You have to cite it within his hearing.
My lord.
In the notes, you cannot.
My lord. My lord, then there's only
You
one
can,
point.
you can collate your,
And
decisions.
I'll just place my lord KK Dinesh, my lord.
No, you mentioned the proposition, that will also do.
My lord.
And refer to that will also do.
My lord.
But then without citing it in open court, you cannot put it in the submission.
Definitely, my lord. I'll just, my lord, then place Union of India versus KK Dinesh, my lord.
What is
The proposition, this is also a matter relating to Assam Rifles in a different rate, however. The question of pay parity and the power of the courts to look into pay parity. Why I am emphasizing on this? Because that there are disparity in the initial ranks and pay of the persons serving as clerks, my lord, in Assam Rifles now. Some are getting a higher scale, some are getting a lower scale at the initial
What is
pay.
the
only.
citation?
This is, my lord, 2008, 1 SSC 586. And in fact, this judgment is the genesis of the judgment of 2012 also. I'll place copies now or my lord file later on.
Any other?
My lord, that's all.
You wish to cite
Yes,
it?
having
Which?
this. I'm having this 2012, volume 12, SCC 291.
2000?
2012, volume 12, SCC 291.
491.
291.
What is the proposition?
Proposition said dismissal specially in preliminary stage does not constitute a binding precedent.
Sorry?
This special dismissal specially petition in preliminary stage does not constitute a binding precedent.
On the issue of
Issue of law, Your Lordship. This Supreme Court has passed a judgment in another case, our dismissal of our appeal in a SLP. So it doesn't constitute the
Yes, there is no merger, there is no precedent
Yes,
of the
no,
Supreme
yes.
Court. But the High Court judgment becomes fully operational
my lord.
and binding
So,
as a precedent for whatever value it is. That's all.
so another is there, Your Lordship, 2011, Volume 7, SCC 397,
2011?
Volume 7,
Yes.
SCC 397.
Yes.
It is there cannot be equality in illegality. So I have done some illegal matters. We have given to somebody benefit. So this benefit to not be constituted that it is the benefit to be continued again.
All right.
And another is there, Your Lordship. 2019, Volume 8.
Why did you say I've concluded my submission?
Yes.
After it is made CAB, written submission invited, then
Yes, yes.
decisions have been cited. Yes?
The 2019, Volume 8, SCC 294.
Yes, what is the proposition?
This is the proposition, there cannot be any parity in illegality.
All right. That's all.
Yes.
You include that in your notes and put append photocopies of those cases.